So we thought we'd start by each of us telling you sort of what we do, our sort of broad area, because family law is quite a broad church, so you've got sort of various different aspects to it, and I think we sit at different ends of the spectrum, sort of, with where our practice is. And then we're going to open up to you guys for some questions, so you can find out what you need to know, because frankly, I had absolutely no idea really what a family barrister did when I was sat where you're sat. So I am going into my third year of tenancy at QEB, so I'm fairly junior. QEB does mostly financial remedies work, so that is sorting out finances when a couple are divorcing and what's going to happen with the house, how they're going to house the children, and then when you get sort of towards the upper end of the spectrum, how you're going to divide a much bigger asset pool. But my stuff, because I'm so junior, is generally really difficult questions focused on housing, where there's not a lot of money and you're trying to split one household into two. I also do a little bit of private children work and Family Law Act applications, so domestic violence injunctions, but I don't do any of the public law side of family law, which is sort of the third limb if you're going to talk about three limbs of family law: money, children, private children, and then public children law, and that's where Grant comes in.
So my name's Grant Keys. I've been a family barrister for about 16 years, and I do that other spectrum. So I do public law. So effectively I do all the horrible stuff. So whether it's shaking babies, whether it's broken bones, whether it's sexual abuse, domestic abuse, so that's what I specialise in. So what I'm doing is normally representing the children or the child, and fighting for their rights of what should happen to them. So you can imagine that if a child is brought into hospital with a broken bone or some injuries, the doctors start being suspicious about how do they occur, it doesn't fit with what the parents are saying, all of a sudden then the authority get involved, social services get involved, then it comes to court, and at that point then the child needs to be represented. So I'd often represent the children to go from there. So that's we do come from very different spectrums. I started doing a mixed practice, so I started doing, for all of you, I started doing criminal, family and civil. That's how I started Pupillage, and I naturally then went into family law. So we certainly come from very different areas.
And I think in fairness as to what Grant's just said, there is an increasing trend now for family law to be a little bit more specialised. I think fewer sets, I don't know if you disagree with this, but I think fewer sets do mixed pupillages. Often you'll find quite a lot of specialist family law pupillages out there. And within that, some sets will do sort of a broad public, private, finance pupillage, and you'll get to see kind of the full spectrum. And other sets, like mine, will do a slightly more specialised pupillage within that, and then equally there are some sets where you'll see mostly the sort of care work and the stuff that Grant does. So actually, even within family law, you've sort of got the option of looking at lots of different areas and maybe picking whether you want to be broader or more focused from the start. So with that little introduction, it might be that you don't have any burning questions, in which case we'll start talking about things that we perhaps wish we'd known when we were applying about what it is that we do day to day. But if anyone has any questions straight off the bat, we're very happy to take them. Yep.
Yeah, my name's Grant Keys. Unfortunately, Kelly was poorly today, but Keyes. So 3PB. All right. Can I ask a question then? So, when a client comes to you and says, I should be getting 90% of that profits, all the house, how do you deal with that?
So, very good question.
It's his fault. He caused the issues. I want all the money. How are you going to deal with it?
It's not unusual, and the short answer to that is usually that's not what you're going to get. And being upfront and managing expectations, well, it's not generally speaking, being upfront and managing clients' expectations is quite a big part of what I do in financial remedies work, because, as I said, sort of alluded to before, where you're dealing with not a huge amount of money or even a reasonable amount of money that a couple has generated throughout their marriage, and they've got responsibilities and they've got children, and there are difficult issues with child arrangements also going on. The bottom line is that if you're splitting one house into two, that comes with a cut in lifestyle, and that comes with a cut in the income that you've got available to you, and it also comes with a cut in where you're going to be able to live. And the starting point as a general matter of law, is you split everything down the middle, subject to departing to meet needs. But the difficulty with that is, well, everybody wants more, everybody says they need more, and when there's not a lot there, everyone needs more than is there. And it's quite important when you're particularly junior starting out at the family bar, you'll have cases where you haven't possibly met the client before you turn up at court that day. So you have about an hour before the hearing, and they will say to you, you know, X, Y, and Z about all the sort of background to the reasons why their marriage broke down, which is usually not really relevant, and they'll say to you that they think they should be getting 90% of everything because obviously they've been terrible and they've left me, or whatever it is. And you've got to quite quickly bring them round to a position where they're able to sit and take your advice, and where they understand reasonably what they're going to get out of the process, because the worst possible thing certainly private family law is ending up at court. You know, there are many dispute resolutions options available to families, and by the time they've got to court, you've already spent a lot of money to get there, to possibly not get that much out of it at the end, and trying to balance their expectations and just make sure, you know, from early doors that you're saying to them, I can't tell you what you want to hear because you're not going to like the advice I'm giving you, but it's something that you need to hear because that's my job. It's my job to tell you what's likely, not what's completely unreasonable and I'm going to fight for in a courtroom, because it just doesn't really help anyone. And there's a bit of a responsibility, I think, and I don't know if you disagree with this, that comes with family law when you're dealing with individuals in a very stressful situation, and you've got people who don't really necessarily understand where the sort of process they're going through, because no one ever thinks they're going to end up there, and they are very reliant on the advice that you're giving them, and you've, I think, got to be very realistic about it. I don't know about you.
No, I agree. So I think one of the questions I have for you, mate, and it's a rhetorical question to me as well, so what skills do you need for family law? Because I think one of the key issues you've got is dealing with people. And you've got to be very sensitive. As you said, you know, you're dealing with people who, you don't know what their background is, you know some of it, well, they might be a heroin addict. They might have, their partner's been having an affair, they might have accidentally dropped their child, you don't know all the details yet. And so, and they've got these wrong expectations. So you've got to be, someone comes to you very angry, they're very aggressive, they hate everyone, they hate all the professionals. How are you going to deal with that? And I think that's one of the skill sets that certainly family law, you've got to be able to deal with people. You've got to understand what they're like, understand their situation, understand legally their position, and also be able to convey that in a very sensitive and direct way to them at the appropriate time. So you've got to understand when it's the right time to say they're being unrealistic. If you start doing that straight away, you're going to start off a very difficult relationship with your client because they're going to not like you immediately. If you gradually build their trust and you explain to them why, these are the reason why you're not going to get 90% of your what you think you're going to get, actually you're going to get 40%, and these are the rationales why, and you build up that trust, you can do that. But rather than us keep asking, have you guys got any questions? Because you've come here for a reason. I know it's Pupillage Fair. Today's about family laws. Any questions that you would like particularly to ask, please?
Thank you guys so much for giving this talk to us, first of all. And my background is mostly in ADR and arbitration.
Yep.
And I've seen, I mean, very few times, I don't have much experience, but I've kind of had a chance to see how emotional and how aggressive these cases can be. And I do realize, and I've read websites and I've gone through courses, and I've heard that you have to be emotionally sane yourself to go through that process with the client, but seeing how bad it is through negotiations, and then you go to mediation, and then you go through arbitration, and by the stage it gets to you guys, how do you truly handle those clients who have heard legal advice, probably from lawyers, from family members telling them that you're being unreasonable, and this is just not going to happen? How do you guys actually manage those expectations of these clients who, I mean, post-Halsey, have reached the stage where now they're in front of you, ready for this adversarial, aggressive process? How do you manage these people, truly? That's the question I have. Because it's just, I have very little experience. So in my head, it just.
I think it's really. Can I answer that initially, and
Of
I'll
course.
come back to you? Give you a couple of examples. One is when they've gone through that, they have some expectations. Sometimes they want a really aggressive barrister, and they want you to cross-examine the other person really aggressively. That's their expectation. And what you have to do, you have to manage the expectation. So for one example, I've got mother and father together, and I've acted like, I know they've gone through mediation, and unusually I got them in the same room and try and mediate it. And sometimes it works and sometimes it doesn't. The other one I've got, so last week, where they've been through every possible process with all the legal advice, and they are not going to agree on anything out of principle. They just won't. And because they've gone through that, despite what you say, despite your set expectations, they're not going to do that. So what we had to do, is you go through the process of cross-examining. They're cross-examining your client, and you're cross-examining their client, and you do that, and you do it all to nth degree. Because even though you've set expectations, you have to go through that process. They've got to a point where they don't care. They will not agree on anything. They won't even agree on what curtains they want, on who has the dog, or whatever it is. They will not agree on anything. Out of principle, they won't. So you have to go through that process, and you go through that, and then you know, quite rightly, the judge makes a decision. They won't like the outcome, because there is no outcome they're going to like. Even like the financial side, they won't like it. Whether it's on the family side, my side, they still won't like it from a private law point of view, but you know the judge decides. So you have to, my point of view, you have to judge it. That's where it gets complex, because you have to judge your client, what you're saying professionally, their client, what the other counsel's like, their style. You've got to judge that very quickly. Can you trust them? Can you not trust them? And I know I shouldn't be saying that, in a very professional environment, but you still have to judge barristers from the other side. What is their aim? So it's a very good question, but a very complex answer.
And if I could just ask a follow-up question.
Yeah, of course.
I understand that the context, the work itself is very stressful, it's very emotional. I don't think I'm built to deal with the cases you deal with on a daily basis. But on top of that, you have clients who have reached the stage where they're prepared to fight. They understand that the winner takes it all, and we're going to walk into that courtroom and someone's going to cry. How does that affect a barrister, a lawyer? What's the emotional toll? And how do you know if you're the person for such a job? How do you prepare for the effect it's going to have on you in the long term?
Well, I can take that, because I can start by taking that, because I'm obviously at a much earlier stage of my practice, and I also deal with less emotionally charged cases than you do, frankly, because what I'm doing is, like you say, you do the horrible stuff generally. I, at the start, was quite surprised, perhaps naively, by the sort of amount of emotion that was flying around in some of the cases that I did, simply because I'd gone into it and I'd not had much experience of family law before I started. That being said, we as barristers are not our clients. We are there instructed on a case. Their lives are not our lives. And it sounds perhaps a bit callous, but the more cases that you do and the more times that you go in and you see these situations, you look at it and you go, well, my role here is to give the advice, to take instructions from my client, to support them through a process where they're vulnerable, and to make sure that they're able to participate as fully as they can. But ultimately, whilst we're dealing with family law, we can't fix everything in their lives. Even though the content of the cases is personal, that is coming before the court, ultimately, it's not our life that we're dealing with, it's theirs. And we can't fix every single aspect of it. What we can do is do what we can to help them get the best possible outcome out of what is a very horrible situation in quite a lot of cases. And being able to switch off at the end of the day is something that it's a big topic at the family bar at the moment, in terms of well-being, in terms of how we manage our caseloads, in terms of how we make sure that we're not taking on what can be some quite traumatic content in cases that we do. And it's something that everyone, I think, has to learn how to go through themselves and how to manage themselves in being able to distance themselves from what's going on and what happens at the end of the day. And my way of doing that is to remind myself constantly that whilst I might be standing up and speaking for this person, I am not that person. And all I can do today is help make it a bit better, fulfilling the role that I'm here to do. It is much, much easier said than done. And there will still be cases. I have cases that keep me up at night sometimes. And you get better at it the more you go on at trying to distance yourself from it. And then another one comes along that you're surprised by. But it's a learning process, I think.
I think for me, I agree with that completely. I think for me, there's probably, of all the years I've been doing it, it's probably 3 cases that stick in my mind. Because they were so extreme. And also, certainly one of them sticks in my mind because you had some physical extreme issues, but also the mother had some real psychological issues. So she had called DID, dissociative identity disorder, which used to be the multiple personality disorder. And because of that, so it was effectively taking a psychological element and what's happening in reality made it very, very complex. So dealing with that was incredibly complex, also complex for the judge as well to unravel the reality of what actually really happened from, psychologically what you think happened as a mum, and physically where's the medical evidence to actually what really happened. So I think the well-being is an interesting one. We all have ways if you have to escape, whether it's stress, whether it's running, whether it's going out with your friends, whether it's, the good thing about the bars, certainly when at 3PB they have whether it's WhatsApp groups, whether it's like social events, so you have to have that, way of stepping you out. Even with my family, my children, I just say, I work in the real world because I deal with some of the horrible stuff, and we both deal with horrible stuff, but actually at the same time, at least that's not the norm, so you have to so there's the wedge of your axe saying that's what I'm dealing with, but that's step back and thinking that's not normal society, so you have to try and step back if you can and go, actually, let's take a bit more perspective of life. Yes, that's what I've been dealing with the last week, 2 weeks, 3 weeks, but that isn't the normal case. Not every child that goes into A&E with an accident, most of them are genuine accidents, and they've happened because they've fallen over, because they've bumped into a friend, because something happened generally, not because they're being abused by their parents. So I think the well-being in the bar is a big topic at the moment, and it's really how you deal with it. Some people deal with yoga. It's life generally, isn't it? Social media pressures, it's very difficult. It's a big issue. But I think for me, I can step back. So I've got a question at the back, thank you.
Thank you for being very honest about some of the challenges that you faced in family law. I was just wondering if you could give some examples of some more rewarding challenges that you face, and have you found there's a lot of scope for learning in every level of your career, or you still feel like you're learning even now?
I'll take that first in sort of 2 parts. So in terms of still learning, yes, I'm still very much in the camp of what we would call a baby barrister. I've had 2 years of tenancy. I'm our second most junior tenant in Chambers. And with that comes quite a bit of comfort that I can say that I'm still a baby barrister, because it does mean that I am conscious all the time of the fact that will be cases that come across my desk that I will just not have seen before, or there'll be a new area of law, and you constantly do get to develop and take on sort of slightly bigger cases and to push yourself and try and take on different types of applications within financial remedies that you might not have done before, and speak to when you do get stuck, go and speak to someone senior and say, actually, I'm thinking about this and I'm not quite clear on whether my judgment on this is right, and so can I just run through it with you? And we've got, you said about WhatsApp groups in Chambers, we've got this sort of similar sort of open door policy. You can walk in and people are very generous with their time. So you learn as you go along, and it's a very steep learning curve, particularly in your early years of practice. There are also very rewarding cases in family law. One that springs to mind for me was I had this horrible, really acrimonious private children dispute that had been going on for ages. We'd had our fact finding, no allegations that were necessarily that serious, but it was these parents just did not get on. Everything was awful, everything was toxic. The local authority had been involved because of how toxic the parents' relationship had become, without it, as was found, straying into abuse. And then we come back for the next hearing, and we had a judge who looked at me and my opponent, and we went in and we said, no, I think we are actually going to have to go to trial on this for the arrangements of the children because we can't agree. And the judge looked at us, and we were there at 10 o'clock, and he looked at us and said, the only way that I'm listing you for a trial on this is if you come back to me at 4 o'clock today and tell me that there's a trial, you're going to go outside and you're going to see what you can do. And both of the parents, who up until that point had sort of just not really spoken to each other at all, came up to us outside the courtroom door and said to both their lawyers and said, are we allowed to speak directly about this? And we both went, okay. And the four of us sat down in a room and we spent an entire day effectively mediating between them. And that hadn't happened to me yet in those sorts of disputes, because as a barrister, often you're coming in at the very adversarial stage of litigation. And it is litigation, it's family litigation, but it's litigation. And by the end of the day, we had an agreement, and these parents were sort of crying and hugging each other, and we were sort of drafting the order and looked up and saw them speaking to each other and went over to check they were okay, and they said, oh yeah, we were just reminiscing about some of the good times. And it was one of those days where I sort of went, oh, there is some good that can come out of this, we're not going to sort of fight. And days like that, they're rare sometimes, but they are quite rewarding when they do happen.
I think for me, I totally agree with that. I think for me, the thing I like about family law is whatever happens, all the complexities of life and people and disputes, is about certainly the child or the children. So, it's the child's welfare is paramount, and that's not underestimated, because that's how the court looks at it, that's how the judge looks at it, saying what's right for this child, what's right for this. So, give an example, quite a few years ago, where I was representing mum. She came in, she was a heroin addict, could hardly walk. She said, I want my child back, could have been removed. And I said, okay, have you got any other friends or family members who recommend? She said, yeah, my friend there, who's lying under the chair, who's also a heroin addict. I want to recommend her to look after my child. So from my point of view, going, this is a toughie. Now, her saving grace was her child was going to then be moved to her brothers, so the child's uncle. I think, great, that's a great option. She can still see her child, great option. And then literally the last day, he said, I don't want to do it. Don't want to look after this child. I know it's I'm related, but don't want to look at it. And it put her in complete shock. So immediately, because she saw the easy option had gone, the next option was adoption. So she said, right, I need professional help. I need to be part of this called the Family Drug and Alcohol Court, where she got professional help, professional support. She got clean, took her, it's a journey, you go through that. She got clean. And we fought and we delayed as much as we possibly could on purpose because it suited her case, and we got her boy back into her care. And when you saw her from when she started, literally couldn't walk, you could see the injection marks on her arms, you could see everything, and her friend lying under to where she came, and she saw me probably about a year afterwards, and oh my God, she was a completely different person, all fantastic, boy in her care, obviously grown up, amazing, amazing. So that's what I love about family law, you get that, and then obviously the flip side of that, you get times where these parents should not look after this child. They've got too many emotional traumas. Might be their fault. It might be because they were abused when they were young kids. So they've gone through that whole cycle and they can't break the cycle. And that child has to be adopted, or a child's going to another part of the family. So I think that's what I love about family. It is very, very rewarding. Regarding learning, you don't stop learning, because all you do is what you thought was a complex case. You've done 20 of those now. It's not complex anymore. So, it's whether you're going high court, whether you're going court of appeal. So, I've got one at the moment which is talking about, it's involved in Russia, Ukraine, Italy, Wales. It's all international. It's all complex because of the war. So, it's very complex legally. So, I'm being led by that for a KC. And so, it's so complicated because it's a moving feast. So, and you don't stop learning. So, the good thing about it, you can go almost where you want to go. You partly go with the work, but also you partly go, where's my passion? Is it commercial law? Is it family law? Is it financial remedies? Is it private law? Where do you want to go? And I think you've got the opportunity to do that. So it's a lot of it's down to you. hopefully that answers your question. Sorry, I know that's a long way of answering the question, but please. So one more, just behind, then I'll come to you.
In terms of career progression in public law, what kind of, how did the nature of the cases you take change from the junior to the senior?
So that's really, that down to complexity. So I think initial might be a contested removal hearing, and then you're building up to, so I've got a 3-week fact-finding hearing in starting December, so that's got all your medical experts, your radiologists, your neurosurgeons, so all it's very medically based, and that's a long hearing. So you gradually build up, so whether it's High Court or where you're going to Court of Appeal. So you naturally do that, and you can do that partly on your own, but also if you're in a good set, which obviously we're both in very good sets, is you can be led as well. And I always used to be, a little bit of stigma about being led by a KC, thinking, I don't really want to be told what to do, I don't really want to do their work for them, but actually you can learn a lot. I learn a lot by, obviously they've been around a long time, their ability to cross-examine, their ability to prepare cases, and that's how you gradually move up. And obviously partly academically, what law you're researching, but a lot of it's really down to doing, particularly in family law, because I'm on my feet every day, so I'm in court every day. So it's, that's depends what you want to do. Sorry, you had a question as well.
Yeah, I have a question. What family lawyers actually do? For example, you were told that there is always money involvement when you separate home for house for one party to another. Do you seek help from convenience lawyers, or you do it only by yourself?
Right, so when I talk about finances on divorce, the court has got quite a wide range of powers when parties are divorcing. So the practicalities, what you just said about seeking help from conveyance lawyers, as the barristers, we're there and we go to court, we give advice, we negotiate around the case, and we might represent at a final hearing. We wouldn't be involved in the actual process of transferring the house or selling the house. That's a separate area of law. But the court can make orders, for example, that a house is sold or is transferred from one party to another when they divorce. So we would have arguments about whether that was appropriate, whether that was the order that the court makes. Because one of the things about financial remedy law that I personally really like is the court has got this really broad discretion. It's quite literally taking into account all the circumstances of the case, first consideration to the children, and the case law has told us effectively that fairness has a broad horizon. So there is quite a lot there to sort of unpack and to tackle in terms of what the right outcome is, and it's discretionary. So there's not really a sort of fixed regime and a roadmap as to what should happen with a couple's finances when they split up. And the judge has got this very wide discretion, which means that in its own way, it's quite advocacy based, because you will go in with competing positions about what should happen, whether it's a straightforward kind of percentage split, for example, or whether or not it's sort of more nuanced and someone stays in the house, you defer a sale. There are limitless things that you can argue about, and there are limitless things that the case law will throw up in terms of differing principles and perhaps competing principles. And you go in and ultimately you can get on your feet and you can advocate for a discretionary outcome. And in quite a few cases, your advocacy is not going to make one jot of difference because there's an obvious answer. And in quite a few cases, your advocacy might make a difference, or you might be able to put a case that is perhaps a bit more creative, or that where it's finely balanced, and it could go either way, and you have the opportunity to make an impact, and that is it's very rewarding when it sort of comes off on your client's side, but it's also academically quite interesting as part of the skill set of the profession. So we don't do any of the sort of implementation stuff, which I think is sort of what you're getting at. We might have to talk to, for example, tax specialists or accountancy specialists, consult pensions experts when we're dealing with financial instruments on divorce that are perhaps a bit technical, or where we need valuation input, because we're not all-encompassing lawyers. We go and we take the advice and we consult the experts on that sort of technical side. But in terms of asking the court to make a range of orders, that's on us.
Thank you.
Yeah.
Last question.
Good. Very good. Sorry, I missed it. Can you say that again? Sorry.
If you know you want to specialise in an area, is it still worth applying to a mixed set? Or is it better just to go for a specialist one?
Depends what you want to do. I mean, obviously, just talking about 3PB, obviously we do commercial and we do family and we do a whole variety. But if you know you want to do, say, obviously family law, then we've got 80 barristers who are doing family law. So you come and do a family pupillage. And you say, I want to do that. If you're not quite sure what you want to do, then you do a mixed pupillage. But if you're very clear, I think it's pros and cons. If you know, some people only want to become a doctor, I knew I want to become a doctor since I was 6, and that's it. And they're privileged in some ways because that's all they're focused on. If you're open-minded, you want to sort of, you know, actually not quite sure, I think I want to go into that, because seeing it in reality is very different from what you think. That's why mini pupillages are great, marshalling is great, because when you see the reality of what it is being a barrister, and even to the point where, do I want to become a solicitor or a barrister? You know, you want to see both, because they can often be very, very different lives. But in your hands, really.
Amazing, thank you.
All right.
Yeah, we're out of time, unfortunately, but huge thank you to Alex, huge thank you to Grant. Yeah, thank you very much.
Thank you.